Good morning to those who are listening to us in Europe. Good afternoon to those who are listening from China. Welcome to EU SME Central webinar series today on how to avoid common labor disputes. My name is Ludmila Hyklova and I am a legal advisor here in EU SME Central in Beijing. Before we start with the agenda and actual presentation, let me briefly introduce USME Central to those who are joining us for the first time. USME Central is a project funded by the European Union, and we are assisting small and medium-sized companies from Europe to invest to China, to set up their company representative office, or to import their products, technologies, or provide services. We started in October 2010, and currently we are in the second phase of our project. At the moment, we are implemented by 6 chambers of commerce. You can see their logos on the screen. What we do, how we are assisting those small and medium-sized enterprises. We have 3 centers. First one we call a knowledge center, which is basically a large database of reports, guidelines, and case studies. We have published over 100 of those reporting guidelines covering sectoral and subsectoral of industries like food and beverage, ICT market, green market, medical devices. From the business development side, some guidelines from the legal and tax area, how to set up a representative office, payment options and foreign exchange control in China, or for example, what you should include to your label when exporting your products. Then on a daily basis, we are assisting companies by providing advice. We are in contact with them via email. So if you have any question, you can visit our website. There is a button, click Ask the Expert, and we will receive your question. And within 7 days, we will get back to you with the reply. We have as well the training center, which is responsible for organizing of seminars, workshops, and trainings, both in China and in Europe. At the moment, we are covering 4 areas of assistance: business development, legal and tax advice, standards conformity, and HR advisory. The easiest way how to get in touch with us is via our website, usmecentral.org.cn, and basically then you can sign up after a very brief and simply registration, which is necessary for statistical purposes in order for us to know that we are helping SMEs and not large multinational corporations. And then you will have access in all those 100 or more publications, and you can as well ask the question to us. One technical slide. On your screen you can see a panel with where you can place your questions. This question will be answered either by my colleague here if it's a technical question, or if it's a question related to the topic, I will answer at the end of this presentation. Or if we do not have enough time to answering all questions, please place your questions via our website, Ask the Expert, and we will get back to you. Little bit about the speaker, which is myself today. As I mentioned, I am legal advisor here in USME Central. I am active in legal advisory for more than 18 years, focusing on foreign investment, company and contract law and labor law, of course. And here we come with our today agenda. What are the common labor disputes and how to avoid them, and practicality and necessity of staff handbook, which is a very useful tool when you would like to avoid the labor disputes. I will focus on the content, what you should include into this staff handbook, and how to make it binding. And of course, I will speak most of the time as well about how to avoid some of the unpleasant situation. At this point, because I would like to a little bit understand who is today in our audience, I would ask a question to you about your background. So let me launch a first poll for today, and the question is whether you are employer in China, whether do you employ people in China, and please vote. I mean, yes, I'm an employer, I'm employing people in China. No, I'm not, but I plan to do in the future. And the third option is I do not intend to become an employer at all. So I can see your votes coming, and let's wait a few more seconds. Okay, I think we have finished. So from the results, I can see then more than 70% of you are employer in China, which is great. 18% is not employer, but you will be in some point in the future. And 12% of you do not intend to become an employer at all. Thank you for your opinion, and I am happy that this webinar will be of great use to you, and then you will learn how to manage your employees. So what does it mean? What you can see on this screen, what I meant by this: business first, HR and employment rules. Yeah, of course it's important, but later. From my own experience, when I came to China 10 years ago as a part of the startup team, we had on a daily basis discussion with the shareholders and the investors, pushing us to set up very soon to get all the approvals and the permits, and most importantly to start a business. So it applies to all managers, general managers here in China, to build business relationship and start to be profitable. Well, in order to do so, you have to hire people. And so what the poor country manager does as its priority, he starts to search for the people and hiring them, and hiring who will help him with all the startup effort. And the general manager wants the people start immediately, and when he finds someone suitable, qualified, speaking foreign language, he is utmost happy and does not bother much himself to pay attention to such unimportant things like whether labor contract has all mandatory provisions, whether the performance assessment mechanism is in place, or whether set up rules for overtime work. Everything goes well, business develops, everybody is happy till the moment that a small misunderstanding between boss and subordinate appears, e.g. for the performance or salary raise, and then finally you find out that you do not have, as a manager, you do not have sufficient evidence to prove that this performance is really below the standard because you did not set up the standards for the performance. That you cannot find the labor contract because so far you needed HR department only for hiring people and calculating salaries, and they put all other HR effort, including in filing documents, on hold. So maybe as well employer's copy of the contract miraculously disappeared. So all this I'm saying to persuade you to pay duly attention to setting up the rules correctly and place them in time. So what are the most common labor disputes and how to avoid them? Most disputes in China comes from the working time and overtime and the corresponding compensation for that. Then comes the bonus payment, reasons for termination of employment contract, and with this is connected as well compensation for employee when terminated the employment contract. The best way how to avoid this situation is, and very natural one, is to have a written labor employment contract. Since 2008, written employment contract is compulsory. There is only one exception, and it is for the part-time employment. What will happen if you do not have written labor contract concluded within 1 month or within one year of the commencement of the work? In addition to being liable for twice the salary, the employment relationship will be deemed to have established a permanent relationship. So there are quite serious consequences if you do not conclude a written labor contract. Foreign companies, normally they do not have a problem with concluding written labor contract. What they have problem, it was something what I have mentioned at the beginning, that they do not file the contract properly, and at the moment when they need it, they cannot find it. So it's connected as well, the proper HR management system. There are some regulations related to the content of the employment contract. According to the law, you have to put into the employment contract, it's quite natural, identification of both parties. You have to mention in one of the clauses for how long employment contract is concluded. Basically, there are 3 options according to the Chinese law. You can have contract which is fixed term, open-ended, or project-based contract. For a fixed term contract, there are as well some other rules. For example, if you conclude with one employee, within one employer, one employee 2 fixed term contracts, then after the finishing of the second fixed term contract, you have to conclude indefinite contract. So this is important as well to have it in mind. From the list, which is on the screen, you can see that the content is quite important, very obvious, but definitely it's not sufficient for regulation of employment relationship. Of course, you can put more provisions into the labor contract, but often it's not practical, especially when you know that you would need those provisions change often, and you need those provisions to be flexible. In such cases, it is advised to put these provisions into the amendment or into the staff handbook, which I will speak a little bit later. So basically what the staff handbook is, it should be a practical source of information for both, for employer and employee. The language should be clear and understandable to average employee. It should be comprehensive, but still not excessively lengthy. It is internal rule providing guideline on employers' and employees' rights and duties. It provides details on employment contract and the provisions. It can contain provisions and should contain provisions of code of conduct for management purposes, and it is as well effective instrument and proof of the content of employment relationship when it's needed. Basically, when it comes to the dispute and you need to prove that employee hasn't fulfilled what he was supposed to fulfill, then you have to have it in written. Here are some of the suggested clauses. Recruitment requirements and on-board procedures, working hours and overtime, remuneration rules, bonuses and social welfare, paid annual and any other leaves, discipline measures including right for termination, confidentiality and non-competition, performance assessment, general behavior, pension plan, trainings, workplace security, procedures, And important things, special rules important for particular business. Of course, there will be a different staff handbook for the company which is manufacturing, different staff handbook for the company which is active, let's say in food and beverage business, because there has to be included some hygienic obligations and duties and so on. So there is some general structure which you have to follow all the time, but as well you have to take into account your particular business. From all those suggested clauses, I will pay attention only to those who are highlighted, which means working hours, overtime, discipline measures, performance assessment. First, working hours and overtime leaves. And before I go to the details of explanation of different working hours systems here in China, let me test your knowledge of labor laws, labor regulations in China, because 70% of you said that you are already employing. So my question is, if an employer stipulates in the contract with the senior management that all his or her overtime is considered as working time, and then you have option. It's legal and the employer will not pay any overtime to the employee. It depends what local regulation says, and the employer has to have special consent from specific respective authorities. Okay, so I can see your answers coming. Okay, so only 60% of you voted, which means that 40% you are not sure what option to select. And from those 60%, 50% says that the employer has to have special consent from the respective authority, and 42% think that it depends what local regulation says. And only 5% think it's legal, and that the employer will not pay the overtime. Actually, the truth is somewhere between 50% and 45% of you. Basically, there is a general regulation saying that if you don't want to calculate overtime and you don't want to pay overtime, don't want to compensate the overtime, then you have to have a special approval from the competent labor authority. However, that this is the general condition. However, it always depends on the local regulation, how flexible they are. So the general rule is that you have to have a special approval from the local authority. So now we move to the working hours, overtime, and leaves, and what are the regulations in this area. Basically, a standard working hour system, e.g. for the office workers, is generally it's the same as in Europe or many European countries. 8 hours per day, 40 hours per week, at least 1 day off per week. There is rule for the overtime, 3 hours per day maximum, no more than 36-hour overtime per month. Compensation for overtime or additional compensation for overtime is either overtime payment, or employer can compensate the employee working overtime by additional time. Calculation of remuneration or compensation is for the working day 150% of basic hourly salary, for the weekday 200%, for the public holiday 300%. I mentioned as well that there are some other types of working hours system in China. And those two systems are, the first one or the second one is called comprehensive working hour system. And under this system, working time is calculated based on specific periods, such as per week, per month, per quarter, or per year. However, the average daily and weekly working time in the set period should follow the rules of the standard working hour system, which you can see on the screen. Which means then, in other words, the average daily working time should not exceed 8 hours, and the average weekly working time should not exceed 40 hours. For whom this comprehensive working hour system is meant to be. This system is mainly applicable to employees working in industries such as transportation or the railway, or the telecommunication, aviation. Basically, there where you cannot have the standard working hour system because of the specifics of this of the industry. The third type of the working system is non-fixed working hour, and this is the system which applies to the case or to the questions which I asked. Under this system, you don't need to follow the working time as calculated under the standard working hour system, and it mainly applies to employees like senior managers, salesperson specifically, or those who cannot follow the standard working hour system, like drivers or loaders. Why I am mentioning these rules for the regulations related to the working hour is just to give a basic background, and this will be followed by clauses which is necessary to include into the staff handbook, and it is the attendance rule. And part of it is as well the attendance record filing. So in order to manage the people and avoid disputes over the overtime or the working hours, you have to keep records about employees' attendance. You can have the electronic system, you can have a simple attendance list, or both. I strongly advise, even it is very old-fashioned, to have a simple piece of paper with the table where each employee coming to the office, to the workplace, sign up and says what time arrived and what time is leaving. It has proved to be as a priceless piece of paper when you need to prove whether the employee worked or didn't work overtime. Another useful regulation is overtime and leaves approval procedure is necessary. If you need your employee to work overtime, or if your employee needs to finish some work and needs to stay in the office longer and needs the overtime, then it's suggested to have a written application form submitted in advance, not after, but in advance, and this approval should be signed by a person who is subordinate, who is superior, who is supervisor of the employee. And all these documentation has to be filed and kept safely in the personal file of the person. It may seem to me as a lot of bureaucracy, but only till the moment when you have your first dispute. I met a lot of managers, especially the foreign managers, saying that they would like to have a liberal approach to the working hours, saying that it is important that the work is done. They do not care whether the employee is in the office or not, or how long is in the office or not. that they rely on people's consciousness and responsibility, that they trust people they have chosen, and so on. But once you have one employee, one worker starting misusing your benevolence and a lack of the rules, lack of the regulation, then the whole workplace is affected, and discipline is ruined. It's not very difficult, and it's not very painful to set up the rules from the very beginning and ask employees to keep the standards. What is very helpful is to include definition of absence from work into the staff handbook. Here are some of the examples which you can put into the staff handbook, like absence without asking for leave or without obtaining approval for leave, absence after leave without completing the proper procedures for leave extension, and include as well into the staff handbook rule sentence saying that absence is a serious violation of the internal rule. This will help you in case you have an employee who is not following the rules, is constantly late, has a unexcused absence from the work. First, you will have a record to prove it, and second, you will have a legal basis to terminate the contract, or before that, to adopt some disciplinary measures. Performance assessment. I think that there are only very few people who really enjoy performance assessment exercise, both from the employer side and the employee side as well. It is troublesome to allocate and to find time for it, and in most cases, employee is not excited about outcome, as she expects promotion, higher salary, or so on, but it does not happen very often. And it is usually a moment as well when the conflict between employer and employee may arise. So it is worthy to be well prepared for it and have in advance agreed rules which can facilitate passing negative information from the employer side to the employee side. Here are some of the most useful types of the assessment, and you should describe those types in the staff handbook. First one is probation assessment. Basically, after 1 month, 2 months, or 3 months of the probation period, you shall sit with the employee, irrespective you want to terminate, irrespective you want to not prolong the contract, or you want to keep the employee. You shall sit with the employee and do this assessment. Another type is annual assessment, which is basically meant for the adjusting the position of the employee or the salary change. I will speak about it a little bit later. And the third very useful type is assessment for the annual bonus. Some of the employers, they put into the staff handbook or even into the contract that the annual bonus is paid to employee only based on the employer's own discretion, based on the profit status or business operational results. This is very useful, but however, if you have an employee who his contract was terminated in November, and his results are good, he has no, disciplinary measures and so on, but you decide not to pay annual bonus to him, while you will pay all the bonus to all his colleagues, then you might, and this employee who finished in November decides to go to the labor arbitration, you might have a problem with the evidence to prove why you have decided not to pay annual bonus to this employee, and what is the ground, what are the basis of such decision. So what I want to say is that even if you have this kind of sentence that it is in the discretion of the employer to pay or not to pay annual bonus, still you have to do, or you should do, the annual assessment or the assessment for the bonus to have evidence saying why you have decided not to pay the bonus. What is very important is to have a written procedure on the bonus evaluation. Naturally, the procedure is formulated by the company, and it has to be shared with the employees before it becomes effective. Shared does not mean that employees have to agree with it, but they have to have opportunity comment, express their opinions. Not very often you can have this procedure for the performance evaluation as an appendix to the staff handbook. You can have it as an appendix to the employment contract. You can have it separately as an internal individual independent internal labor rule, but you should have it. So this is the procedure which is applicable for normally for group or all employees. But in addition to that, you shall have individual KPIs for each employee, and these KPIs should be discussed at the beginning, say at the beginning of the year, and then the following performance evaluation shall be recorded in written and filed at the employee personal records. It is recommended not to have the performance evaluation only once per year, but let's say once per 6 months to give you the some basis if you would like to make any changes in the position or the salary adjustment of the person. Here is one of the examples where the evaluation is very useful, and it is in the case of the unilateral position adjustment from the employer side. I mean, of course, there are cases when you are adjusting a position of the employee, that you are promoting him higher, making his salary higher. But from time to time, there are as well situations when you are not satisfied with the results of the employee, and you want to adjust the salary. And based on the Chinese law, you can do it unilaterally under these three conditions: that the employee is not competent to perform and to continue in the position. In case of employee suffering from the illness or non-work injury and cannot continue to do her job, and employee has fulfilled orally agreed adjusted position for over 1 month. From all those three options, the most often what's happening is the first one: employee is not competent. But here you have to prove that the employee is non-competent, which means that you have to have definition of incompetency somewhere written, either in the contract or job description or in the handbook. It should be specifically measurable and objectively being able to evaluate. What is as well useful, and I can understand that for not every company, especially for the small companies, it's not very practical, but you may think about it. to have not only the rules for the staff position evaluation, but as well somewhere specified salary levels for different positions. And this one will help you then to, when you want to adjust the position of the employee to the lower level, to explain in case of the future of the potential labor dispute why you are doing so, that you have some conditions which were not fulfilled, and what will be the salary for the lower position. Now comes the most painful part of the employer-employee relationship, and it is termination of the contract, which when employee does not agree. So in the following few slides, I will speak about the termination from the employer's side. Basically, there are two types of the termination from the employer side. First one is termination with so-called severance payment or 30 days notice. And the second option is immediate termination. So first one, this. Again, incompetence is one of the reasons when you can, as an employer, terminate the contract with the employee, giving him 30 days prior notice or paying him a severance payment instead of the notice. All the others are the employer proposes a termination and the employee agrees, contract expires, bankruptcy, and so on. But again, incompetence has to be proved. Otherwise, you will be considered as terminating the contract, labor contract, illegally. Immediate termination from the side of the employer. It can happen when the employee is being proved not to be qualified for the work during the probation period. That's quite clear. And then there are some serious violation, like committing corruption or dereliction of the duty, working at the same time with for some other employer, concluded labor contract by way of the fraud, which means I didn't inform you about some important circumstances, and based on those circumstances, the contract was concluded. The person, employee, is investigated for criminal liabilities. And again, something what has to be mentioned in the staff handbook, and it is seriously violating internal rules and regulations of the employer. What is seriously violating internal rules and the regulations of the employee, of course, cannot be set up at any law. It has to be specified in the staff handbook itself. As you can see, this is, for those who are familiar with the topic, these are closest provisions from the law. However, a lot of employers include these basically copy-paste these provisions from the law to the staff handbook itself. It's very practical because when you hire an employee, you give him sign the labor contract and you give him the staff handbook. So it's something like a booklet, basically handbook, which the employee has in the hand, and it's a comprehensive overview or the guide through the rights and the duties. Of course, before you terminate the contract with the employee, you should take some measures which precedes the termination. Here we can see some usual and recommended disciplinary measures. Normally is used an oral warning, witness, or recorded in signed meeting minutes. Many people or many managers, they do the mistake that they invite a person constantly coming late to the office, to the meeting room, and say, oh, you know, it's not possible how you are doing it, I'm giving you the oral warning. But then there is no record of the oral warning, so even it is oral warning, it has to be recorded somewhere, and ideally it should be witnessed by some other employee, but it has to be recorded and filed. The second level of the warning is a written warning, and then it comes has to be again letter delivered to the employee. If the employee does not want to hand over, it does not want to receive, does not want to acknowledge that the written warning was sent to him, that again can be witnessed, or it can be delivered by the recorded mail. And of course, one of the last disciplinary measures is the dismissal or the termination. I'm mentioning it again, but it has its reason, that the violation of any rules shall be proved and recorded. It should be recorded in written, signed by the employee, ideally, or provably delivered to the employee, witnessed by the superior. You invite into the room HR or someone from the legal department, or if you are a larger company, you will have a disciplinary. You can have a disciplinary commission. Now, consequences of illegal termination. When the employer is considered to illegally terminate the contract with the employee, is when he terminated the contract for other reasons than those allowed by the labor contract law, or without any reason. And the consequences will that the employer will either need to reinstate the employee back, which is not very often. What is more often is that the employee will pay damage to the employee with a general amount to twice the rate of the severance pay. What is as well important, and as someone sometimes or often neglected, is the approval and the publication of the staff handbook, or generally to any internal labor rule. So the easiest way, of course, is that you have labor contract, then you have a staff handbook, you hire an employee, you ask him to sign the contract, you ask him to sign the staff handbook. But what will happen if you have to amend the staff handbook? You have to include some new provisions. What will you do with the current employees? As I mentioned somewhere before, employees not only has to be aware of the change and the content of the change of the internal labor laws, they will have to have as well the opportunity to comment, to express their opinions. So what is the practical value, what is the practical way how to do it, is to set up a meeting, have a list of participants somewhere next to the door, ask employees participate at the meeting, sign the presence list, do the presentation on the changes of the staff handbook, and then put the staff handbook together with the presence list and store it somewhere, file it somewhere on the safe place. So in a summary, and for a revision of most of what I have said, I will tell you the one case study which happened. And you can find cases like this, many cases like this everywhere. Basically, employee in a managerial position working for a company for 3 years and 6 months and he was performing quite well. But last couple of months, 6 months, the employee was not performing according to the management expectation. So what the management of the company, what they did, they decided to terminate the employment contract. They saw that they did everything what was needed. There was 1 month's salary instead of 1 month's notice paid to him. Then he got 3.5 salary as an economic compensation for his employment period, and that's it. Employee didn't say anything. He signed the papers and left the company. But the next day, he went to his lawyer, and together they went to the labor arbitration. And they asked for the twice economic compensation for illegal termination, which means twice multiply 3.5 average salary for past 12 months. He claimed as well more than 100 days of overtime in total. Some of those days were during the national holidays, and as well he claimed proportional part for the bonus for the current year. So now what the company, what they had to do, they had to put together evidence. So the HR legal department, they sit together and they started to do the list of what they have to prove that what they did was right. So first it comes to the employment contract. Well, what happened? They could not find the written contract. Well, actually, they could not find the contract at all, and the reason was that the company has moved, and some of the records were lost. Some of the files were lost. Luckily, employee already submitted the written contract to the labor arbitration, so they did not need to prove existence of the written contract. Then second evidence they wanted to submit was a staff handbook, internal rules. The original staff handbook was duly adopted. The original version was signed by the employee. However, update which continued some, which contained some new rules, including overtime rules, was not signed, and generally was not even proved to be communicated duly to the said employee. Then it comes to the evaluation of the performance, because based on the not sufficient performance, the employee, his contract was terminated. And firstly, the company had no legal rules procedure for the evaluation. They had, or they claimed, they had a meeting with the employee, and they communicated the KPIs to the said employee. However, they even were meeting minutes. However, they were not signed, and they were only 2 people presented at the meeting. It was the supervisor and employee itself. It was for the setting up of the KPIs. However, what is even worse, there were even no meeting minutes for any evaluation of the results which employee should deliver. There was as well no evidence that employee was offered retraining for the same position, which is one of the necessities if you want to terminate or decrease the salary of the employee. There's as well no evidence for that the position adjustment was communicated to the employee. Moreover, a record of the working time was available only partially. So electronic record from the office, on the workplace, it was available, so it was fine. However, the person was a salesperson as well, so they didn't have any record on the working time outside the office. I have to mention as well that this company did not apply for any special working hours scheme, so they didn't have this scheme on like a comprehensive working hour scheme or non-fixed working hour system for the management people, for sales people. So in a summary, what happened is that the person really got his compensation for illegal termination, and company had to pay one more time the compensation for the period which the employee worked. They paid as well the overtime, not all the 100 days, but they pay some part. And what is as well not very encouraging, that they had to spend a lot of time putting evidence together, going to the arbitration, appealing to the court, and again to the second instance, not saying that it didn't contribute to their reputation. So the lessons learned from this case and from all other cases: if you are employing written contract and other documentation, store it safely. As I said, there is no problem to have a written contract. The problem is very often to find the written contract or other amendments, not only the first contract, but other amendments. How make sure that it works? Do the regular audits in HR department. They will not like you, but at the end they will copy with that, and it will save a lot of troubles to them, especially in the future. Have a staff handbook with appropriate content, and make sure that it was adopted duly, which means that it was published and that the staff was given opportunity to comment on it. Sign or ask them to sign the presence list. Important thing which I haven't mentioned, but it's crucial too. Managers, they have to be trained on how to do evaluation. Keep records on evaluation, signed by the employee. If the employee does not want to sign, ask third person to sign the meeting minutes. Keep record on attendance. As I said, the paper is old-fashioned style, but it still works very well. Overtime, allow only upon written approval of the supervisor, previous written approval of supervisor. What has proved to be quite a good measure to avoid the overtime is to include in the monthly, in the slip from the monthly salary, saying that all or no overtime for that month was claimed. By this way, you will at least cut the previous months, and in the worst scenario, you will be obliged to pay only the overtime for the 1 month. And now we come to the questions and answers. I have included as well the link where you can send your question, not only regarding the internal labor rules, staff handbook, labor issues, but any other questions which you may have. And in a couple of weeks, in 2 weeks, we are going to publish an update of our guideline on internal labor rules and social insurance. So you can later on download it. It includes in more detail the information which I have mentioned and some practical advice. And we are as well offering the center, the service. If you have your staff handbook already, or you plan to draft a staff handbook, you can send it to us, and we will review and give some suggestions. And now we come to the questions. We have a question just related to the overtime. Can the employer choose to compensate the employee by time instead of paying additional money compensation? yes, employer can choose to do so. Then there is another question saying how it is calculated, how does severance payment in case the parties agreed on termination of the contract. Sorry, again, in case the severance, in case the contract is terminated, how is calculated the severance payment? Okay, so basically the severance payment is calculated based on the average monthly gross salary for previous 12 months. And this average monthly salary is then multiplied by number of the years served. If the employee works in 1 year more than 6 months, then the more than 6 months is calculated as 1 year. If he works less than 6 months, is calculated as a half year, and the proportional like just half of the salary. Then we have a question. One of my employees is absent for 4 days without legitimate excuses. How to fire this employee? The employer doesn't have the handbook. Well, do you have? I guess that you have a record of the employment. So in such case, I would record of the working hours when he is absent or not. At least this one, the employer should have it. And in this case, after the employee appears, you should give him the oral warning or whatever other warning. And in case of this absence of work without any reason, it should be considered as a serious breach of the employment duties, even if you don't have it in the staff handbook. Then I guess we have time just for the last question, and the question is related to the employment of the foreigners, and it says, can a foreigner have open-ended labor contract, which means non-fixed contract? And the person is asking that she heard something about the 5 years as a maximum. Yes, that's true. The term of the labor contract between an employer and the foreign employee shall not exceed 5 years, and the employment contract shall automatically terminate upon its expiration. So, in summary, it means that you cannot have open-ended contract with a foreign employee. The maximum is 5 years. However, it does not say that you cannot renew the employment contract after the 5 years. Okay, so I think it was the last question of today webinar. Thank you for your attendance and for the listening. The record of the webinar will be available on our website. As I mentioned, we have several guidelines related to the labor issues. One of them is on the labor contract, another one is on the internal labor rules and social insurance, which will be soon updated. So you are encouraged to visit our websites and download them, and as well to send any question you may have. Thank you, and look forward to meet you on the virtual platform next time.